All right, what do you think, Stephen? Should we get started?
It looks like, yeah, we can go ahead and get started. And if any people trickle in, I'll just let them in. Yeah.
All right, sounds good. Welcome to our first workshop of the 2025-2026 season. We'll be talking about this year's case, which is Faizmart versus NLRB, in honor of course, Mr. Faizmart. Um, and we'll be going over a little bit of the facts of the case, some of the major arguments on both sides that are outlined in the case problem, although of course there are plenty more arguments you can make. We'll go over the table of authorities and answer any questions. So I'm Lizzie. I'm the NAMC president for this year, and I'm a junior at Yale. I'm the vice president of our Moot court team, and a former brief hitting captain.
My name is Steven. I'm the NAMC vice president. In the past, I've kind of chaired the brief writing competition for NAMC. I'm also at Yale. I'm a senior.
Right. We can go to the next slide. So yeah, what we're doing today, we'll give you a quick introduction, fact background, and then go over the issues themselves. So a little bit of background on this case. So you may have noticed the fact pattern for this case is a little bit different than you normally see. So we gave you a lot of history of the NLRB, of the difference between law and equity, because there is a lot of more technical terms that you might not have heard so much before. But there is, of course, an actual factual situation that led us here. So Faizmart is a big employer, think Walmart. And employees at Faizmart started to unionize. But there was a labor dispute, and our friend Vikram Ramaswamy was fired for testifying against his employer during this dispute, allegedly. So this is illegal. So he goes to the NLRB, he files a complaint, and he asks for damages. So he's asking for back pay, for reinstated wages, and for some interest on his credit card debt to kind of restore him to back to where he was. So under the National Labor Relations Act, as we kind of outlined in our very long history that you can read in the case problem, this case is decided by an administrative law judge. We have another judge in Moss in this year's case, Delaney Moss this time, and Faizmart is ordered to pay damages. But Faizmart is going to appeal this and claim this violates their Seventh Amendment right to a trial by jury on cases at common law. And then meanwhile, Faizmart's also making another challenge in our second issue based on the unitary executive theory. And it's claiming that the Take Care Act, which is an act that prohibits ex parte communications, so outside court communications between the president and members of the NLRB, is violates the separation of powers. And a couple of people have asked, since we covered standing last year, how does Faizmart have standing in this case? And you can kind of see that in seal law. But if this is true, that the separation of powers issue, then the NLRB exercises its power unconstitutionally. And so any order that Faizmart made about it isn't valid. Any order that NLRB made about Faizmart, excuse me, isn't valid. All right. That's kind of the basic fact pattern. And then I'll be going over the Seventh Amendment issue. Stephen will be going over the unitary executive issue. Stephen, did you have anything to add on the facts that I missed? No? Okay. Cool. So let's talk about the Seventh Amendment. So the question presented, which is we kind of give you an overview of the Seventh Amendment. And did the NLRB violate the Seventh Amendment by ordering Faizmart to pay Mr. Ramaswamy for all his foreseeable expenses resulting from misfiring, including that credit card debt beyond just back pay? So we'll start with kind of an overview of what the Seventh Amendment is. So the Seventh Amendment says in suits of common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. So this maybe is a case of, it's certainly a controversy, but is it a case of common law, which is what we'll discuss. So we're kind of going to outline the basic arguments that we used in the case problem on both sides. Again, these are not the arguments you're limited to. These are just some suggestions that we used. So for Faizmart, you're going to have kind of three claims. So first, they're going to claim that this is legal in nature, which means, of course, it's a case of common law. And so the way they're going to do that is by talking about the remedy. So we have a little bit of an overview of the distinction between a legal and an equitable remedy. But because Faizmart's going to argue that because this remedy goes beyond just restoring the status quo, and it's aimed at compensating losses, not just removing gains, it's going to be a legal remedy in nature. So that's kind of one point for why it might be a case of common law and subject to the Seventh Amendment. And then they're also going to argue that this case is analogous to historical cases of common law. So there's a close relationship here to the tort of wrongful discharge, which has a strong history. We kind of trace that history back all the way to Blackstone's commentaries, which is in your table of authorities. Don't worry, it's just like one page from it. It's not very scary. And there's also a dispute about whether we should be looking all the way back there or whether we should be looking at 1935, which is when the NLRB was enacted. Because of course in 1935 there wasn't really a way to just have a labor dispute like this in a common law court, because or in a in a jury trial, just because that was during the Lochner era. There wasn't a lot of protections for labor until the NLRA comes along. But we're saying that's not where you should be looking. Congress can't just invent a new regulatory scheme to strip away a jury trial right. You should be looking back to wrongful discharge. And then we also talk about the public rights exception. So this was a kind of a big deal in Atlas roofing. It's a little bit narrowed in Jarczy, and we're saying it doesn't apply in this case. And of course, the NLRB is saying the opposite of all of that. So that's on the next slide. So the NLRB is going to say that it's not legal in nature. So this is not equitable remedies just to restore the status quo. And this is one of those. We're just giving him his back pay. We're putting him back to where he's before. And that doesn't require a jury trial. Equitable remedies have been historically adjudicated by the executive branch. This is an executive branch agency. That's totally okay. Hi, is there a question? Okay, cool. So it serves a remedial and not a punitive purpose. And then, of course, they're going to say it's not analogous to common law. So they're both going to say dispute the kind of wrongful discharge historical trajectory that we outlined in the dissent. And they're going to say that in 1935, this didn't exist. Again, kind of the opposite of what the dissent was saying there. And then they don't even do the public rights exception. So they should be arguing for the public rights exception, or they could be arguing for the public rights exception, I should say. But in the opinion, we don't even really need to get to that because we win on the first two prongs. You can try to dispute that as well under Atlas roofing. Again, it's a little bit tricky in a post-Jarczy world, but it's definitely still an argument you can make. So yeah, that's the Seventh Amendment. We can take quick questions on that, but we will have time for questions at the end as well. Questions?
Seeing no questions, I'll go ahead and move into issue two, which is kind of this issue that deals with the unitary executive. Just to start off, the question presented here officially is Article 2, Section 1 of the Constitution vests the executive power in a President of the United States of America, and Congress arguably violated the constitutional guarantee when it prohibited the President from communicating privately with certain executive officers. First off, what is the unitary executive theory? So you guys may have heard about the unitary executive theory in the news recently. It's something that's kind of gained more and more traction in recent years, especially kind of under the jurisprudence of Chief Justice Roberts. And it really hinges on what's called the vesting clause in this Constitution. Right at the beginning of Article 2, the executive power shall be vested in a President of the United States of America. And there are a couple of things to notice here. What exactly does executive power mean? Does it refer to the power King George would have had? Does it refer to all of the power invested in the executive branch? Or is it somehow limited solely to executing the laws passed by Congress? And what does it mean to be vested in a president? Are we talking about the president solely as a single individual, or are we talking about the wider structure of the executive branch? Based on how you read this, there's a theory kind of gaining traction that the president really is supposed to be the like single force within the executive department, that they're elected to kind of specifically from federal authority to like have a lot of energy, and that as such, in order for them to do their job, they need to have like complete control over the executive department. And that is kind of something that's kind of pushing against some past cases stuff that suggests that maybe Congress can place limits on the executive's ability to reshape executive departments, or there are limits on that power to really affect the executive branch. So NLRB, their arguments are going to be pretty simple. They're going to be defending the constitutionality of this recent Take Care Act that was passed. First off, they have some precedent. This is Youngstown Category 3, right? This isn't an example of the president just exercising their power unilaterally for executive functions, as would be in Category 1, nor is it I'd probably getting the categories mixed up. But this is an example of the president just executing their powers. This is more of an example of them sharing power with Congress, arguably maybe even sharing power with courts. And when you're sharing power with Congress and courts and this kind of rulemaking and quasi judicial functions, Congress might have the ability to kind of limit the power of the executive branch because these aren't solely executive functions. They're also going to argue that some recent laws, like Myers and Scalia law, do not justify it. This is about distinguishing the power to appoint and dismiss officials as a part of these branches from the power to communicate with them and interfere with their actions. There's been a lot of talk recently about the potential overturning of Humphreys and whether presidents have the power to unilaterally dismiss certain individuals from independent agencies. But there's arguably a difference between having the power to dismiss someone and having the power to try to shape their actions before this dismissal. Finally, arguing that Trump v. US is distinguishable, that there's a difference between protecting communications between the president and his I don't know, underlings officials in the line of criminal prosecution versus just allowing them to affect his arguments, especially because there's this due process issue. The president having this much power might be bad for due process. If they're able to communicate with both the adjudicators and the actual enforcers of this law, who are trying to prosecute these cases, they can make any, like in public, but they shouldn't be able to like tell the judges deciding this case, hey, this is something you should consider, or this is something you haven't heard that the defendants aren't able to respond to. Finally, history and structure. This might be concerning for the separation of powers. You know, Congress specifically set up the NLRB to have some distance from the presidency, and this recent law was passed specifically to further insulate it from executive pressures. So there's some history that supports a degree of officer independence. On the other hand, Faizmart will be arguing that no, we have clear precedent on this, and that there have been recent laws like Myers and Scalia that remind us that the president can remove subordinate officers. So it's kind of crazy to suggest that you can fire someone with for any reason, but you wouldn't be able to contact or communicate with them. They also looked at Trump v. US, which puts contacting executive power officials in the president's conclusive and preclusive power. They also look at history, the vesting clause, Federalist number 70, the energetic accountable executive, and argue that the majority misses context in their historical analysis. Finally, they argue that there isn't a due process issue because the president is the highest adjudicator. And if there is a due process issue, then that comes from issue one. This is a thing that should be handled by courts, in front of a jury, not something that should be handled solely within the executive department if due process truly is as big of a concern as the majority opinion was making it out to be. With that being said, a quick look at the table of authorities.
So we'll start with issue one on the table of authorities. We have three kind of core cases here, which is going to be Atlas Roofing, Brampton and Sierra, and Jarczy, which is our kind of core Seventh Amendment cases. Again, Atlas Roofing isn't overturned by Jarczy, but it is distinguished a little bit, so be careful with that. But Jarczy is a very recent case, so we've seen a couple of things come out of that, and one of those was International Union of Operating Engineers versus NLRB. Stephen, if you can actually go to the excerpt we gave them from that one, I just want to point out that we only gave you linked in the case problem is only the Bumate dissent, and we only have the portion of the Bumate dissent that actually talks about the Seventh Amendment. So there are other issues in that case, and so we specifically pulled out for you the portion that's actually relevant to us, which is this Bumate dissent. I think it's really helpful as a resource. It's not, of course, binding precedent, but it does kind of go through all of those arguments. He is pro Seventh Amendment on this side, so that helps you. But he also does address the opposing arguments. It also gives you a couple of really good excerpts. Actually, this page that Stephen's on right now, from this Dobbs treatise. We did not give you the whole Dobbs treatise because that's a lot. but it does give you some of those distinctions between law and equity that can help on the first prong of the Seventh Amendment argument. And the other case that we only gave you an excerpt of was NLRB versus Jones and Laughlin Steel. So the majority of this case is about the Commerce Clause. It's not super relevant to us. The relevant portion is really these last like 2.5 paragraphs where it's talking a little bit about the history of this NLRB. Again, this is from 1936. The NLRA was passed in 1935. So this is a very recent case. And it kind of draws out in a specific exemption for the NLRB under the Seventh Amendment. So again, we were going to just give you that as quoted in the other cases, but we decided it might be helpful for you to have that excerpt just so you can read the whole thing. You can cite from the whole thing if you want to. So that's why we only have a very small portion of that case linked there. And then if you go back to the table of authorities, we also gave you, again, just like one page of the Blackstone commentaries, which is helpful, I think, just to, because it is cited there. It's not a whole, like you have to read all of this history, but that just one paragraph kind of gives you a little bit of the history of wrongful discharge. And then for a kind of broader outline of that, you can take that Iowa case, which is the Fitzgerald versus Salisbury Chemical. And so that kind of traces a little bit more of the history of wrongful discharge. Again, that's really helpful on that second prong of the test that's outlined in Jarkissi.
The issue authority, two authorities are a bit more straightforward. You have just a series of cases, some a bit older, some a bit more recent, kind of with the increase in prevalence of the executive theory. So Morgan, Myers, Leal, Trump, Youngstown. Then you have a couple of kind of historical documents because this is a very structuralist issue that looks at the relationship between the different branches of government. So we have Federalist Number 70 from Alexander Hamilton, the Annals of Congress, and this letter from Thomas Jefferson that's kind of quoted, that's kind of specifically about a very early example of one of these issues, with Jefferson kind of wanting to maintain some difference, or I guess the dissent would argue just avoid accountability for one of the officers kind of under his purview in the executive branch.
And these are all from founding fathers. They're very kind of originalist vibes. So we have, again, a congressional debate from James Madison, a letter from Thomas Jefferson, Federalist from Alexander Hamilton, and then William Wirt is the Attorney General, an early Attorney General who kind of outlines this as well. So that was the 1823 opinion. Okay, it's his written opinion, but it's not a case, but it's still a really helpful historical authority. And if you kind of need ideas on how to use it, you can take a look at the way the case problem does. So yeah, that's a kind of very brief overview of our 2026 NAMC case. Does anyone have any questions we can answer?
Hi, this is Luis Zambrano. Hi,
Hi.
I have two questions, one for each issue. On issue one, to what extent are students expected to delve into the history of what happened during the Lochner era court and then what happened with the adoption of the National Labor Relations Act?
The students are kind of, it's up to them. We gave them the kind of all the history they would need about the NLRA in the case problem itself. So if they want to explore Lochner, they can. We purposely didn't put Lochner in the table of authorities because we didn't want people to have to really go into that. But if they want to explore the history to kind of inform their opinion, especially kind of on that second prong, they're welcome to, just again, within the limits of the table of authorities.
That anticipated my next question, or I guess a sub question that I have, and that is that we are limited to these particular cases. We can't do any research outside of them.
Yes.
Okay. And then my second question on issue two, I'm not sure I entirely agree that the unitary executive theory is gaining traction. I can't agree insofar as Scalia has mentioned it a couple of times in some opinions. Is there an expectation that that theory will be discussed? Because I'm not entirely sure that it is something that the U.S. Supreme Court has adopted in any meaningful way.
Yeah, absolutely. I mean, we're kind of expecting the Humphreys opinion to come out, or Trump versus Slaughter to come out at some point over the course of this term. But you're absolutely not expected to the unitary executive theory isn't in any of the cases we have. So that's definitely an argument you can make. There is kind of a vesting clause type argument to be made in terms of the structure of the case problem. But you are absolutely not limited to agreeing with the unitary executive and the way the case is structured.
Okay, thank you.
Are there any other questions? Okay, seeing none, me and Lizzie will stick around for 5 minutes. Otherwise, you're free to go. If you want to access this recording should hopefully be uploaded sometime in the next week. Otherwise, you have our email if you ever need to reach us or contact us for any reason. Um, Yeah, you have both our personal emails along with the NAMC email. We're really excited to kind of see your submissions if you decide to write briefs again, to see how you handle this case and oral argument. And stay tuned for information on from future workshops. I'm really excited about this next one. We'll have a few NAMC veterans who were in your positions over the past year or two. Discussing some really in-depth forensic skills, followed by, I think, an amazing discussion about handling questions, hypotheticals, all of that. With that being said, we're excited to start this new season. Excited to see you again. Yeah.
And again, if you have any questions about the case or clarifications, or you find typos or anything like that, please email us case@namcmootcourt.org. We'll be putting out kind of the updated version with just a couple of typos fixed at the end of the month. Or any comments that you have about that, we would really appreciate.